Hey guys, Whitney here. Welcome to the Passive Investing Made Simple show. This is, I can't say our first show since the holiday break. So we didn't take a break during the holidays, but I know pretty much everybody that listens to the show regularly is back in full force. I took a look at the registration list. You guys, if you haven't checked out passiveinvestingwithwhitney.com already, make sure to go over there, because if you want to get more educational content like this that helps you understand the ins and outs of passive investing so you can go into your next deal with confidence, check out passiveinvestingwithwhitney.com. There you can get registered for our masterclass, our monthly skills building bootcamp sessions. And if you'd like, and you can also check out our open deals at passiveinvesting.com. And if you'd like, jump on a call with me to talk about how passive investing fits into your investing goals. Now, I don't want to take up too much time here today because we have a very important topic. And I know, Mark, people are going to be so interested to hear from you. But I want to make sure before we bring you on, two things. That's not Jerem Bergeson, my lawyer. So,
we got the same haircut.
Yeah, that's about it. Haircut. But Mark Fetzer, he is another lawyer. He is graciously stepped in for Jerem since Jerem had a conflict today. But he's also with KKOS Lawyers. Jerem, or Mark, I'm going to have you do your intro here in a second. But I want to make sure I preface everybody, because when we do these shows like legal considerations, tax considerations, everybody starts typing in they see it as an opportunity to get one-on-one legal help. That's not what we're doing here today. We are here to help you understand the 30,000 foot view, those overarching considerations from a legal standpoint that you need to understand as a passive investor. We're also going to, talk about some of those things that just recently, legal changes that recently just went into the effect as of January 1. I'm not going to clue you into those, so you guys are going to have to stay and listen to the end of the show. But if you have questions, I know many of you do, make sure you have found your Q&A box, okay? Not the chat box, the Q&A box, okay? And put your questions in there. That'll help me get your questions asked in line with the show. And then we'll do a little bit of an Ask Me Anything session here at the end of the show, as we usually do. All right. Well, I want to go ahead and say thank you so much, Mark, for joining us here today. I am so sad that Jeremy couldn't be here, but I am so excited that you are here. And so, Mark, would you help us understand what you do here at KKOS Lawyers, but also how you got into securities law?
Good question. Okay, thank you very much for having me, Whitney. I appreciate it. And no one can fill the shoes of Jerem, but I will do my best. I shaved my head today specifically for that, so I could somewhat fit in. But so I have been with KKOS Lawyers for about 3 years. Prior to that, I was in public accounting. I worked for multinational entities with international taxation, regular taxation, entity, personal, etc. I tried to run the gamut. And then I found KKOS Lawyers, and they were exactly what I was looking for. And so I came here because I truly enjoy helping the individuals who are not multi-hundred, multi-millionaires, billionaires, multinational corporations. I like to help Main Street individuals who are looking to diversify, take more control over their finances and their financial future and picture, and really help them understand the complex nature of the U.S. tax system. And so that is how I became involved with taxation and KKOS specifically.
Oh, fantastic, fantastic. And so we aren't going to pepper you, hopefully, with a whole lot of tax questions here today. I'm sure some will slip in. But yeah. I wanted to kind of like start off, what are some of the benefits that, people that are listening here today that are either already invested in a passive syndication or considering investing in a passive syndication? What are the benefits to them when they invest in a syndication that, everybody should be aware of?
So a syndication is really a great vehicle to enter into the real estate market. Oftentimes people think that entering into the real estate market requires them to go out and buy a long-term rental or a short-term rental, and they don't necessarily understand that there are easier methods to entering into real estate investing. Syndication being the primary one, because you can join a group of individuals who are potentially more experienced than you are. You can reduce the amount of risk, reduce the amount of overall investment that you are required to make, and you are able to get into some of these larger type investments, commercial, retail spaces, larger apartment complexes, et cetera. So it provides much more diversification than you can generally otherwise get on your own.
Mm. And I love that you pointed that out, because, I wanted to purchase a, say, 40 or 50 or even $80 million multifamily building. That's not only is it an arduous process, but that's a lot of capital to have in one building, where, as a limited partner in a passive investing project, you can now take what capital you have and diversify it. What I say over operators, markets, and deals, right? So you just don't have that single point of exposure.
Exactly. And you just brought up a really good point. You said a limited partner. So in that case specifically, you are also significantly reducing the amount of liability exposure that you have, so that if something happens with the investment, you are more protected than if you had gone in as a general partner or as a whole owner on your own, or through through a different structure.
Mm.
So that's a critical aspect to remember as well. You're keeping yourself out of the courtroom more effectively that way as well.
And as somebody who has had and still has actively held real estate, that's a real thing. I've never been sued, but sometimes situations get a little out of hand. You're like, wow, where is this going to end up?
Exactly. Where is it going to end up? And so with a syndication, you have more anonymity. You also have less exposure. Now, that's not to say that you can't establish another type of structure to help reduce the liability if you are into wholly owned real estate as well. However, syndications make it much more straightforward.
Well, and I want to get into structure here in a little bit, but we have all different walks of or levels of passive investors that are listening to the show. And so I want to make sure we start off with the basics, and then we'll move into the more nuanced parts of investing in passive real estate. So now that we've understood, established what a syndication is, I wanted to kind of talk about what are the drawbacks potentially of investing in a syndicated asset that, a limited partner should be aware of. Go in eyes wide open.
It really comes down to control. You are providing your money to someone else to invest on your behalf, and you are relying on them to maintain the entities properly, to choose the investments, to do the due diligence properly. You are not in control of the boat, and so it could crash and you could lose your investment. It's as though you are investing in a public entity that could file bankruptcy. It could go under. There could be many different issues. There could be embezzlement. There could be fraud. There could be any number of issues that arise. You are just not in control. And that's my biggest concern.
Mm-hmm. And that's what I spend so much time with our passive investors, here at passiveinvesting.com, but also, people who are interested in getting in passive investments, in something that we don't offer them, maybe like in mobile home parks or something like that. But I really help people understand that you do have, while you don't control the day-to-day operations of the asset, there are certain things that you can go into eyes wide open that give you an ounce of control, like understanding your goals, your risk, your timeline, getting really good at vetting operators, right? You're
Yes.
the CEO. You got to hire a good COO to help you manage that asset, and then getting really great at then vetting the market and then the deal itself. I see so many investors that, new passive investors that come into the space, and they're so fixated on the returns of the asset that they forget that their biggest exposure probably is going to be, did the operator do the good work up front?
Exactly. And you bring up a good point in that it depends on the level of commitment that you also want to have in this investment. And so it is critical to have a team around you that can help you vet these investment opportunities, help you realize what you are getting into, what you don't know, just what questions you may not know to ask.
So, okay, so, we get into the tactical tools, those questions and stuff like
Yes.
that, but you mentioned team. I'm big on team. It's a topic we cover regularly, but for those people who are like, I missed that class, like, who should be on your team?
So I'm a little biased, right? I'm an attorney, but I think that you should have a good attorney on your team, a good attorney, a good CPA, and someone who is or can fill a mentor type role, who has gone through multiple deals and has gone through the school of hard knocks. Maybe they've lost some money. Maybe they've had an operator who hasn't done the good work up front, et cetera. Someone who knows the industry and can teach you. Those three individuals are critical because they are going to be able to guide you through every single step and make sure that it is as smooth as possible. There's always going to be some sort of risk involved, but they are going to make sure that your experience is as smooth as possible.
And I love that you bring up the point of risk. It's mitigation of risk, not elimination of risk.
Correct. Yes,
exactly.
exactly.
So help the listeners understand the difference between the two.
So elimination of risk is, and I like to use the analogy of the risk-free rate of return, right? That is an investment term where you go in and you know that the risk-free rate of return is expected to be X. And at that level of investment, you're not taking any risk. You're getting the minimum return that you could likely get. You have essentially taken away as many of the risk factors as possible. And because of that, you are reducing the rate of return that you receive. Mitigation of risk is vetting the various risk criteria to make sure that they are either A, acceptable, or B, eliminated. And because there is still some risk associated with that investment, your rate of return is necessarily higher. I don't want you going into a mitigated risk scenario for the risk-free rate of return. I expect you to get a premium. That's why mortgage brokers charge a premium on top of their mortgage rate that they receive from the Fed, because they don't know you and they only trust what is on the documents. Does that answer your question well enough, Whitney? I'm trying to hit
Yes. And I got a follow-up question here.
Yes.
Maybe a bit of a loaded question, given with, I looked at the inflation rate right now, the last published inflation rate was 3.41%. In the past 12 months, we've seen several bank collapses as well as acquisitions, right? There's a lot of consolidation still happening.
Right.
Does risk-free rate of return exist?
It's a good question. And like you said, it is a bit of a loaded question. I believe it does, right? And let me provide a caveat for that. Mm-hmm. There is nothing in this world that is 100% risk-free. But from a finance perspective, if you look at the risk-free rate of return, it is the extent, it is the rate of return to which as many risk factors as possible can be eliminated from the investment. And so I do believe that there is a quote unquote risk-free rate of return, but you still have a very, very, very small amount of risk. Okay,
risk-free rate, say that 10 times fast. Okay, so a risk-free rate of return actually isn't truly risk-free. Is that kind of sum it up?
Yes.
It's risk-free if you can get it, but it's not entirely risk-free. And I'm not trying to put you on the spot. I'm just trying to draw clarity for like our investors here.
Right. So if you go on to the technical definition of risk-free rate of return, it is the interest rate at which an investor can expect to earn, the interest rate an investor can expect to earn on an investment with absolutely zero risk. I'm an attorney. I'm cynical by nature. I don't think you can eliminate 100% of the risk, but the technical definition is zero risk.
All right. So, Mark, thank you so much for indulging me on that.
For sure.
You took us down a rabbit hole there, but I want to, pull it back up to that 30,000 foot view. So we
Okay.
define what a syndication is. We define that there are, there are some legal implications here, some drawbacks. Now, I talk to hundreds of investors, every year, and here at passiveinvesting.com, currently we work with accredited investors. But some people that might be listening here, they might be scratching their head, like, what does that mean? Could you help us understand the difference between accredited and sophisticated investors?
Yes. So an accredited investor is an investor who meets very specific criteria that has been set forth by the U.S. government. And in order to be deemed an accredited investor, excuse me, I'm stumbling over my tongue today. You have to meet these specific criteria, and as such, once you can prove that you meet these criteria, you have different investment opportunities that open up to you. Okay.
Does the SEC essentially say you can afford to lose money if you're accredited?
That's correct. Exactly. They know that you have enough money that you can lose money, one, but also that you have the ability, you have shown the ability to earn and maintain a standard of living and a standard of financial security so that you are less susceptible to risk. And so an accredited investor, you have to have at least $1 million of net worth or more than $200,000 of earned income in the past 2 calendar years. And earned income is a criteria that we have to define more specifically. That must come from an operational activity, a W-2 job, a business that you operate. It may not come from passive investments. So if your full-time operation is real estate investing, you have 100 doors and you're getting a lot of money, maybe you're making more than $200,000 per year in rental income, you don't qualify. You are not, and that is not earned income. And so you do not qualify under that definition.
Ooh, and thank you for putting that spin on things. How could somebody organize themselves to make that? Would they just put themselves as a property manager?
They could, yes. So, and that comes with potential issues, right? So it really depends on what your investment goals are. But generally speaking, rental income is subject to income tax. Operational income is subject to self-employment tax and income tax. And so in order to take rental income and transfer that over so that you can become qualified as an accredited investor, then you have to subject passive income to self-employment tax, which may not be the best option for you because you are automatically increasing your tax rate significantly. Mm-hmm. But yes, that is exactly how you would do it. You would become a property manager for yourself.
Now, I said I wasn't going to bring you into the tax piece, and I just did that. Let's pull it back to the legal side because I just potentially opened Pandora's box for us with questions.
Okay.
So, okay, we're going to reset a little bit. Okay, so we've got our accredited, we've got so we define the accredited investor, right? Somebody with $1 million of net worth, or they can meet an income test as $200,000 earned income individually, $300,000 jointly with a communal partner. There's a couple other like oddball qualifications in there, like if somebody's really compelled to take a Series 7, 65, and 82 license. Did I get that?
Right.
Yeah.
So yes.
What is a sophisticated investor then?
A sophisticated investor is a much lower threshold to meet, and a sophisticated investor is merely someone who has experience investing in a given market. So I can be a sophisticated investor because I know a lot, but I may have lost my shirt in the market. And so I am therefore not an accredited investor because I don't meet the income.
Gotcha. Okay. So, you know, and I know we operate under Regulation D 506C. So we work, you know, with accredited investors.
Right.
And then I a lot of times questions that I get when I speak to investors that are like, well, why not work with sophisticated investors? Is there an advantage for an operator to work solely with accredited over, you know, a sophisticated investor?
There's less risk in working with accredited investors, right? Obviously, if you are issuing a PPM or some other type of investment documentation, you obviously have to follow those regulations. However, an accredited investor comes to the table with the expectation that they understand the risk, they know the risk, and they are willing to take the risk. A sophisticated investor has a lower threshold. They can claim less knowledge and potentially claim a greater cause of action against you because they don't meet that higher threshold of investment acumen.
Got it. Got it. Okay. So, and I find this very interesting because I have met so many sophisticated investors that are incredibly knowledgeable and so many accredited investors that I am so thankful that we have our educational programs so they can get plugged in. It's an interesting definition that the Security and Exchange Commission has put in place. It's constantly being reviewed and potentially updated. But guys,
Yes.
these are the rules by which the operators have to play by. We don't get to choose the rules.
No, no, you're absolutely correct. And the SEC does not mess around when enforcing or investigating these rules. They take these very seriously.
Yeah, yeah. If I'm talking to investors and I can totally, they are completely 100% knowledgeable. We can't slide you into a deal, unfortunately. That's just not how it works. But again, those things are always up for review and amendment with the Securities and Exchange Commission.
Right.
Now I want to switch gears just a little bit. So we talked about syndication, accredited versus sophisticated. I think we kind of got everybody caught up with the base knowledge. Majority of the conversations that I have with investors, they're wanting to engage in legal counsel, not only to understand the investment, we went over that, but also how they should invest their dollars in the asset or potentially title it. So can you help us understand advantages, disadvantages, pros, cons, or why somebody would invest as an individual versus joint with their spouse versus using an entity?
Okay, absolutely. So, and I'm going to add another wrinkle to this, if you will. My opinion is that everyone out there should be investing through a trust, and this is a revocable living trust. The reason being is, yes, you have your retirement accounts. Those are not owned by the trust. However, in order to avoid probate and make the transition of your assets to your beneficiaries much more streamlined, you need to marshal them in a manner that includes a trust, which is merely a probate avoidance vehicle.
So for those people that don't know what probate is or
Okay.
how painful it can be, I've been through probate 4 times.
Yeah.
Let's kind of pick that apart for a second.
Okay, probate is the judicial process through which an estate changes hands. So when a loved one passes away, typically we're talking about parents, and the nuance with spouses we won't get into unless you would like to, but the probate process typically is when a parent passes away, they have a will or they may not have a will, but in order for the courts to feel confident that that individual's wishes are being taken care of, you must go through a judicial process called probate, where you open probate with the courts. It can be a supervised or an unsupervised probate. There may be a bond that is required. It usually takes between 6 months to a year. It can take much longer than that. If someone has a will, probate is going to be faster than someone who dies intestate, which is without a will. But the judge essentially oversees the distribution of all assets. There must be an accounting provided by the executor of the estate in order for the judge to sign off, and then you close probate and the assets are transferred.
Yeah. And I think the number one pushback that I hear people say, like, why they don't consider a revocable trust, or why my family members didn't do this, I'll pick on my family first, is they're like the cost of it. And I'm like, if they knew how much I spent in probate, time, yes, energy, like in money, right? Like, anyways, that, yeah, I mean, I think with my mom's estate, I easily spent $40,000 just trying to settle all of her things. So
unfortunately,
it was not a complicated estate, really.
But it can become very expensive. And you picked on your family, I'll pick on my family. My father passed away. He did have a revocable living trust. However, he failed to transfer one brokerage account into the trust. And that one brokerage account triggered probate. And that probate for that one account took approximately 6 months and cost more than we charged to set up one trust.
Yeah. All right. So let's get back. So your recommendation or suggestion, and again, this is global commentary.
Yes.
Make sure that you talk to a legal counsel to make sure that this fits for you, your actual investing situation. But instead of considering even individually, jointly, or in an entity, first, let's start with the trust level. All right, so I kind of derailed you from your commentary on that. So I'll turn it back over to you.
That's okay. The trust really is, as we've talked about, a probate avoidance vehicle. And so for anyone who has assets, who has loved ones, who wants to avoid the process of probate, the trust really is the foundational piece of any investment structure. And then how that structure evolves from there is dependent upon various criteria. With the trust, if you are married, then it can be a joint trust, and then you can invest from there. And so you are investing along with your spouse or significant other. As an individual, it's the same thing. You are investing from this one single entity. Now, as far as investing with a spouse is concerned, there are different ways that you can title assets. So for example, if I wanted to go out and acquire a piece of property with my spouse, but I didn't have a trust, then I might sign up as joint tenants with right of survivorship, or a very common structure is tenants in common. Those are different ways that you can title assets and potentially avoid probate and avoid a trust at the same time. But there are other potential issues that may arise. And Whitney, if I may I share my screen? This will help, I believe, yes, provide context to my comments.
Yeah, absolutely.
Thank you. Okay. And then let me know if you want this to be any larger than it currently is.
No, I think we're good.
Okay. So as you can see here, the trust is the foundational piece. And then I have here two different sections. One is a retirement account section. Another is a regular passive section. If we were going to be talking about coming back to the property management type scenario where someone has a lot of passive investment income, but they want to become an accredited investor, then we would have another section over here that has your operational entities. We're not going to touch on that today unless you would like to. However, this trust should own an investment entity. This investment entity is going to invest in various types of real estate. Now, this entity right here is called a charging order protection entity. And I'm getting into liability type exposure here. This COPE entity is not necessary for real estate investments. Okay, so we will ignore this for 1 minute. If you are acquiring rental property, whether it be short-term or long-term property, you want that to be in an LLC. And the reason being is that provides liability protection for any liability that might arise inside the LLC, so that liability does not attach to your personal assets. And there are some conditions to that, but that's the general function. Now, with that entity, as long as it is a single member entity, you do not have to file a tax return. You report the income and the activity on Schedule E of your 1040 tax return. However, if you invest with your spouse, then you become a partnership and you have to file a Form 1065, and it complicates your investment structure a little bit, makes it a little bit more expensive, a little bit more complex. There are certain circumstances, primarily in community property states, where you can have two people in an entity, but still have it considered to be a disregarded entity. But that's a rabbit hole that I don't think we want to get down today. So with that being said, if you invest with a spouse, then you can complicate your investment structure. If you invest alone, it makes things much more easy as far as the reporting is concerned. And there are other strategies that we can utilize to still involve the other spouse, just not make them a legal owner and therefore more complex. Before I move on to the COPE entity, Whitney, is there something you'd like to comment on?
No, I think that's great, because I think what you're about to get into is the COPE, which is where, what excites me, because while it adds additional layers of protection, from what I've experienced, can also help streamline things.
Absolutely. Absolutely. If you are an individual who is going to go invest in maybe a syndication, a short-term rental, a long-term rental, maybe partner with some other individuals on other types of investments, the COPE absolutely is a simplifier in that structure. And what the COPE does, the charging order protection entity, is typically a Wyoming entity. And the reason being is states that have COPE laws, not every state has a COPE law, but states that have COPE laws have different requirements. Wyoming is the most protective, and it provides protection for single member entities. Therefore, your trust may be the only owner of a COPE entity and still provide strong protection. Now, what a charging order protection entity is if you create liability yourself, maybe you get into a car accident, or there is some other type of personal liability that you have a judgment against you for. In order for these individuals to access the assets, your real estate assets behind a COPE, they have to go through Wyoming first. They have to chase the chain of title. Now, if we are talking about other states, let's take, if I remember correctly, Arizona is what is called a foreclosure state. There are three different types of states. There's COPE, there's foreclosure, and there's dissolution. With a dissolution state, the judgment creditor can come in and force a dissolution of your membership interest or the entire entity in order to access those assets to satisfy the judgment. A foreclosure state is similar. However, they can foreclose on your ownership interest in that entity and either take over the entity or become a business partner with your other partner. No one wants that. We want to be able to choose our business partners very carefully. A COPE entity is where there is a charging order, a judgment against you. However, in order for that judgment to be exercised or attached to any asset, the individual, the entity essentially has to provide a distribution to the owner of the entity. And therefore, the charging order can attach to the distribution. It cannot force dissolution or foreclosure of an ownership interest. And so these charging order protection entities can be critical aspects in maintaining a very secure, asset protected, liability protected investment structure. Now, the caveat there is the charging order protection is not perfect. Right? There are ways for courts to get through it, but the idea is that it is so much more difficult to get through a charging order entity that you will either settle out of court or the lawsuit will not be brought at all. And then the other benefit is with the entity being in Wyoming, you have the ability to create greater anonymity than you would be able to do so in many other states.
Got it. And that was going to be my follow-up question. It was like, okay, well, what happens if it does get through? But it sounds like the game that's being played, if I may call it a game, is that, you know, it's kind of like game of chicken in a way. Like we're banking that the other people are either not going to put in the effort,
Yes.
right? Or we're going to be settled in some other, you know, settled out some other way.
Exactly. So whereas someone, if you're in a different state without charging order protection, a judgment creditor could come after you and attempt to attach that judgment to your assets for, say, 15, 20, 30,000, a nominal amount. With a cope, it's likely going to cost them more than that just to get through the cope. And so the judgment essentially becomes worthless at that point.
Gotcha.
So it is kind of a game of chicken. That's a good way to put it. I like it.
I'm always looking for ways to simplify things. That way people can kind of wrap their head around it. Now, I know we've got questions coming in, guys. I will take a look at the Q&A box here in a minute, but I wanted to, you know, so we talked about the legal part of this. Is it really as simple as setting up this type of legal strategy, or are there additional banking and bookkeeping considerations?
Very good question. Every entity that you have must have its own bank account and its own records. And that is getting into what we term the corporate veil. Each entity, so we talked about outside liability. Liability you create yourself personally, car accidents, etc. Inside liability we touched on earlier as well. That's a liability that arises inside an entity. A tenant slips and falls or something of that nature, and they try to sue you. Under the entity premise, they sue the LLC and not yourself personally. And in order for that liability to remain captive inside that LLC, the corporate veil must be maintained. And as part of that corporate veil, you must have your own bank account, books and records, no commingling of funds. You need to keep your entity registered with the state and file an annual report every year. Even though the state may not require an annual report, you need to have an annual meeting and an annual report in your binder. And so if someone comes to you and says, we're going to pierce the corporate veil so we can reach your personal assets because of this liability that was incurred, you can hand them your corporate book and they will understand that piercing the corporate veil is going to be much more difficult and not productive. So you are absolutely correct. Bookkeeping, bank accounts are the minimum. Now, don't get me wrong. There are some platforms out there that can offer a very good service of helping you to set up an entity. However, the misconception that registering an entity with the state is sufficient for liability protection is completely wrong. You must have an operating agreement. You should have organizational minutes. You need to have an annual meeting. You need to have a bank account. You need to have various operational documents set up in order to maintain that corporate veil. If you walk in with your one page from the Secretary of State, your corporate veil is pierced, essentially.
Mm-hmm.
So
now,
be careful.
I also want to put out to people, because that might be very eye-opening for a lot of people that did, you know, hoodwink it and set up their own LLCs. Mm-hmm. There are ways to clean this up.
Yes, absolutely.
Right? Yeah.
There are absolutely ways to clean it up. I'm sorry, go ahead.
Well, I was like, make sure to talk to your legal team in order to help you do that, right?
Absolutely. And a pound of prevention, or an ounce of prevention, is worth more than a pound of cure in this case, because you may spend $1,000 cleaning up your entity with your legal team. However, the peace of mind and the liability protection that you receive in the event something happens is going to be much, much more valuable than that $1,000.
Thank you. All right. Now, at the end of the year, the Corporate Transparency Act, yes. I should say at the end of 2023, into last year, let's be very clear, a Corporate Transparency Act went into effect. I wanted to touch on exactly what that is, why it's in place, and how that impacts people that have a entity that was open prior to January 1st.
So the Beneficial Owner Information Act was established or promulgated by FinCEN, which is the Financial Crimes Enforcement Network. It's a subset of the Department of the Treasury. And what the goal is here is to reduce as much as possible the money laundering, illegal crimes that are being perpetrated through various entity structures here in the United States. So the objective is very good, right? We're trying to eliminate money laundering, trafficking, drug running, etc., all of the crimes that have a major detriment to society. FinCEN is trying to curtail. This is not something that you need to be afraid of. It is going to require an additional filing, but any entity that has been established prior to 1/1/24 has until the end of 24 to file this form. Now, some people have been very concerned about the invasiveness of this form. They do require a picture of a photo ID. They require home address, various personal information items that you may or may not want to provide. The biggest misnomer that I've heard is people think that they will provide this information and then it will be available on a public database for anyone to search. That is not the case. This information is information that the government already has. We are now just tying this information to a FinCEN report and to an entity. Okay? And technically, FinCEN says they are going to keep it very private. Obviously, there's the risk of data breaches, et cetera, but we have that with the IRS. Again, all of this information the government already has as well. It's not going to be public. And so make sure to have that filed by the end of 24 if you have a pre-existing entity. For any new entity that is set up from 1/1/22 forward, you have 90 days to complete the beneficial ownership information form for FinCEN. Now, the penalties for not filing this form are incredibly steep. They start at $10,000 and they can go up $500 per day. It is not something you want to mess around with, but it is also something that I do not feel you need to be afraid of.
Now, does this go for any LLC and trust? Is it also for LLCs that are held by retirement accounts? Like, what is this? What qualifies here?
Good question. We are primarily concerned about entities that are held by individuals that are smaller businesses. There are 32, I think 32 exceptions. Maybe I'm dyslexic and it's 23. There are quite a few exceptions, and I can provide those. But for the most part, if you have an entity that owns real estate or owns a business, then you need to file this form. With a trust, a public accounting firm, certain nonprofits, those are some of the exceptions where you do not have to file. So any entity, LLC, S corporation, C corporation, LLP, etc., those entities need to file.
Gotcha. All right. Well, Mark, we've gone over quite a bit of content here, and I want to make sure we save a little bit of space for our Ask Me Anything part of the show. It's been such a wealth of knowledge. And of course, this is just information, educational information for you to take back to your own investing team. So Mark, if somebody wanted to follow up with you and, see if, this type of structure is appropriate for them, how could they get in touch with you?
Thank you for asking. Here's my information. I noticed you had this with Jerem last time, so I figured I should probably follow suit. This is my email address and the office phone number. Please feel free to reach out and I will do my best to assist you. If I'm not a good fit, I will say so, and I will try to find someone who can be a good fit for you.
All right. Well, and I wanted to ask a kind of a double-edged question as we wrap up here. What should a limited partner stop doing right now, in your opinion, and start doing instead?
A limited partner in a syndication or in just in general?
Let's take it in general.
Okay. So a limited partner in general needs to be very careful. Do not stick your nose into management. Otherwise, you could be reclassified as a general partner with unlimited liability. The reason you are a limited partner is for limited liability. Don't mess that up. Right? So don't be involved in management where you don't need to be.
That is a great tip. I hadn't thought of that, but thank you so much for sharing that information and that knowledge with our limited partners here today, and really any investor that's listening. We look forward to following up with you guys here in the near future and learning about other legal considerations.